Bloomberg Audio Studios.
Podcasts, radio, news.
This is Bloomberg Law.
What does a prosecutor have to prove in order to get a RICO conviction? Tell us why the Solicitor General is sometimes referred to as the 10th Justice.
Interviews with prominent attorneys and Bloomberg legal experts.
That's Jennifer Kay for Bloomberg Law. Joining me is former federal prosecutor Robert Mintz.
And analysis of important legal issues, cases, and headlines.
Is the toughest hurdle for prosecutors proving Trump's intent? Alito took on Congress, saying Congress has no power to regulate the Supreme Court.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to a special holiday edition of the Bloomberg Law Show. I'm June Grasso. Ahead in this hour, we'll take a look back at some crucial Supreme Court arguments this term. The justices considered regulations on ghost guns just months after a landmark decision on bump stocks. We'll also look at a unique death penalty appeal where the state of Oklahoma is siding with the death row inmate. But first, the liberal city of San Francisco found itself in an unusual position at the Supreme Court, taking on the Environmental Protection Agency over sewage discharge into the Pacific Ocean, with a $10 billion fine on the line. The city's attorney, Tara Steele, argued that the regulations were too vague.
They might as well have said, do not violate the Clean Water Act. It doesn't tell us anything.
But the liberal justices pushed back on San Francisco's arguments. Here are Justices Elena Kagan and Sonia Sotomayor.
It's prescribing that you have to meet water quality standards. Like, how more clearly could you meet this statutory language than that?
What they're asking you to do is to become responsible for doing what's necessary.
The ideological divide was apparent, with conservative justices expressing concerns about the fairness of the city facing billions in fines without knowing what its obligations are under a vague permit. Justice Brett Kavanaugh challenged the EPA's attorney, Frederick Liu.
You're suing San Francisco separately for a lot of money based on a standard that they had no idea, at least that's the theory. That's the theory in your position. Your position would allow that.
I don't
yes,
think so.
It would.
I mean, the Bayside complaint is Exhibit A for why what you said is not going to be true.
And Chief Justice John Roberts pointed out that Congress had updated the law to address the kind of concerns that San Francisco was raising about a lack of clarity.
The bad old days is when we had water quality standards, right? People didn't know what they were supposed to do, how it was going to be allocated, sort of a problem of the commons, and they put in the permit system. And I think the danger here is that you're going back to the other system.
Joining me is former U.S. Solicitor General Gregory Garr, a partner at Latham & Watkins. Greg, tell us about the city's argument here.
So the city of San Francisco is concerned about the lack of fair notice that they have in terms of how to comply with the Clean Water Act as to the sewage discharge that's going into the Pacific Ocean. And their argument is that the Clean Water Act obligates the EPA to set specific effluent limitations on the amount of pollutants coming out of plant sources, discharges like the pipes going into the ocean. And that instead, what the EPA has done here is just issued these vague water quality standards. You have to be sure that the water is a particular color where the sewage is coming out, or, it meets other criteria. And the city's argument is that, well, they don't know how to meet those criteria. There's other sources coming in, who's responsible for what. And, all this is against the backdrop of a suit brought by the EPA in which they're seeking, according to the city, literally $10 billion in penalties. So the city feels as though they lack the fair notice that they were entitled to under the act up front in terms of what discharges could go into the ocean.
Did it seem like the three liberal justices were pushing back on the city's argument?
Definitely. Justice Kagan, Justice Sotomayor, and Justice Jackson all leaned in hard against the city on their arguments. And they took a number of different tacks. Most importantly, I think they really wanted to focus the city on the text of the act and put the city on its heels in terms of identifying a provision of the act that stripped EPA of the authority to issue these sorts of broader water quality standards. And Justice Jackson in particular pointed to the language in the act which says that the EPA could adopt, quote, any more stringent limitations, end quote, and argued that, the city was wrong in saying that the limitations were limited to effluent limitations coming out. The justices also had hard questions for the cities about the potential environmental impacts of the city's position, which at times got pretty gross in terms of talking about floating toilet paper and the like. But the city definitely faced a tough crowd from the more liberal end of the court.
And the EPA's attorney faced a tough crowd from the more conservative justices. Tell us about his argument.
So his argument was that, number one, that the statute did confer this more broader authority on EPA, and that it could be exercised in particular instances, more limited circumstances, and that here he claimed that the problem really was one of San Francisco's own creation, and that he claimed that EPA had asked for specific data from the city about its discharges and the like, and the city never provided it. And so according to the EPA attorney, they had no choice but to issue these more general water quality standards. And, really one of the more interesting dynamics of this oral argument is this was the city of San Francisco, one of the more progressive jurisdictions in the country, facing off against the Biden administration EPA. And it was clear that there was no love lost between them, at least as to this particular issue.
Yeah, well, this is a case where the city's Board of Supervisors voted 8-2 to urge the city officials to resolve the suit quickly. There being a concern that a Supreme Court ruling in the city's favor could have sweeping implications for curtailing water pollution.
Definitely. And it's unclear how far the court would go, even if it ruled for the city in this case. There were justices sort of probing more narrow rulings. And I think, even if the court ruled in favor of the city, it probably would, try to limit the reach of its ruling. But, the basic question on the table is whether EPA has the authority to issue these broader water quality standards, which is something that, as the Chief Justice pointed out during the oral argument, that, this is what the prior regime did. It issued these general water quality standards and set a specific discharge limitations. And in his view, and this is what the city argued, that the Clean Water Act was actually enacted in part to replace that regime with one which gave the dischargers more notice up front in terms of the specific limitations that were permissible.
And did it seem, just as the liberals were taking issue with the city, that the conservatives were taking issue with the EPA?
Well, there was a group of them. There was the Chief Justice, Justice Kavanaugh, and Justice Gorsuch pushed back the hardest, I think. And the main concern that sort of unified them was the lack of fair notice to the city and other dischargers in this situation where, as I mentioned earlier, potentially these jurisdictions are on the hook for significant penalties, in this case, literally billions of dollars according to the city, and they don't know exactly, the city argues, and the conservatives sort of picked up on, how to comply with the Clean Water Act in this instance, particularly where there are multiple discharges going into the same place. Who's responsible for what in terms of figuring out whether or not the water quality standard is met. But there was some uncertainty, at least, in terms of where the other justices were. Justice Barrett, who actually joined the more liberal justices in an environmental case last term, Ohio versus EPA, didn't join the stronger attack by the other conservative justices and seemed to be probing a narrower angle and dealing with these challenges under the arbitrary and capricious doctrine. Justice Alito picked up a little bit on the government's argument that in this case, the problem was that San Francisco hadn't provided adequate data to the EPA, leaving it with the predicament that it had to issue these more general standards. And Justice Thomas definitely had some tough questions for the city, although his position was a little bit less clear. So, San Francisco coming out of the argument, I think, should feel good about its position, but it's not over yet.
Are other cities in the same position as San Francisco? Have the same problems?
So I think that the use of general water quality standards is definitely not the norm. But one thing that came up during the oral argument in response to questioning from Justice Kavanaugh was that there was, many amicus briefs filed, friends of the court from businesses, municipalities, and the like, who had serious concerns and reservations and problems with the EPA's approach here and, talked about the dangers and lack of fair notice with this sort of more general water quality standard regime. And that was something that resonated with Justice Kavanaugh at least, and probably some of the other justices as well.
This is the first case to grapple with federal agency power since Loper-Bright was decided last June. That's the case that overturned Chevron deference. Though you didn't hear much about Chevron deference in these oral arguments.
No, not a word. EPA certainly didn't ask for it. And, it was clear that this was going to come down to what Congress actually said in the statute and the court's best interpretation of that, which, of course, is the way it works after Loper-Bright and really the way it has worked at the Supreme Court for many years, even before Loper-Bright.
Do you think that we're just not going to hear about Chevron deference in future arguments at all, or about that concept?
We're definitely not going to hear about Chevron deference. I think the more interesting question is, will we hear about other types of deference, so-called Skidmore deference? How aggressive will the government be in trying to claim some type of deference in other cases and try to push back a little bit? And I think that that'll be an interesting trend to follow in the court this term and beyond.
The EPA has faced a string of losses at the Supreme Court in recent years. For example, with the court curbing its ability to reduce greenhouse gases and to protect wetlands. Does it seem like in some respect it's going to lose in this case as well, whether it's broad or limited?
I don't think that that's a certainty at this point. I mean, one of the other questions that came up during the oral argument was whether or not there were some flaws with this case and maybe the court should just not decide it altogether. But, I think you're going to feel better about the oral argument coming out of it if you're San Francisco than EPA. And I think, EPA and the government more generally has been sort of behind the eight ball in these administrative challenge cases. And, EPA sort of finds itself in a particularly difficult position when you combined aggressive enforcement of its environmental priorities with broader statutory provisions, which is the area where the Supreme Court has been particularly adamant in demanding that the agency point to more specific authority in the statute for what it's doing.
Thanks so much for coming on again, Greg, and sharing those insights with us. That's former U.S. Solicitor General Gregory Garr of Latham & Watkins. Coming up next on this special holiday edition of the Bloomberg Law Show, the justices grapple with whether ghost guns meet the federal definition of a firearm. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Thanks for joining us for a special holiday edition of the Bloomberg Law Show. I'm June Grasso. We're looking at some high-profile Supreme Court arguments from this term. Still ahead, we'll dive into an unusual death penalty case that finds the state of Oklahoma siding with a defendant on death row. But first,
these guns were being purchased and used in crime. They were sold to be crime guns. There was a 1,000% increase between 2017 and 2021 in the number of these guns that were recovered as part of criminal investigations. And it makes perfect sense because the whole reason why you would want to get your hands on one of these unserialized, untraceable firearms is if you are a prohibited person or you want to use that gun in a crime.
Solicitor General Elizabeth Prelogar argued that the Supreme Court should uphold the Biden administration's regulation of ghost guns, nearly untraceable firearms that can be assembled at home in as little as 20 minutes.
Those untraceable guns are attractive to people who can't lawfully purchase them or who plan to use them in crimes. As a result, our nation has seen an explosion in crimes committed with ghost guns.
During oral arguments, the justices grappled with the question of whether ghost guns meet the definition of firearms under the Federal Gun Control Act that would allow the government to regulate them. The analogies were plentiful. Justice Samuel Alito, who seemed skeptical of the government's argument, compared the gun kits to cooking ingredients.
If I show you, I put out on a counter some eggs, some chopped up ham, some chopped up pepper and onions, Is that a Western omelet?
No, because again, those items have well-known other uses to become something other than an omelet. The key difference here is that these weapon parts kits are designed and intended to be used as instruments of combat, and they have no other conceivable use.
But Justice Amy Coney Barrett jumped in, comparing gun kits to meal kits.
General Prelogar, I just want to follow up on Justice Alito's question about the omelet. Would your answer change if you ordered it from HelloFresh and you got a kit and it was like turkey chili, but all of the ingredients are in the kit?
Yes.
The best analogy seemed to be if you buy a bed from IKEA that you have to assemble, is it still a bed? Joining me is Kevin Tobia, a professor at Georgetown Law. Many people might expect that this is a Second Amendment case since it concerns guns. But tell us what the question before the court was here.
So it's not a Second Amendment case. It's a statutory case. So it concerns the Gun Control Act of 1968. And there's two questions in the case. And so both of them involve the meaning of different language in this statute. So the question in some ways is actually kind of simple, right? Before you get to like all the kind of complexity that they were working through, which is what counts as a firearm for this law. And so these gun parts kits, they're marketed and sold as kits that you can buy and assemble and construct into a functional firearm. So, a lot of the conversation was drawing analogies to different sorts of goods, playing kind of with language and trying to understand, what counts as an omelet or what counts as a table, right? So Justice Alito offered this example kind of hostile to the government's position that if we just have, peppers and mushrooms and eggs, that's not an omelet yet. So in the same way, like a collection of gun parts is not a firearm yet. And Justice Barrett actually sort of responded and said, well, what if those come in a HelloFresh kit? We actually might understand that as an omelet, even though it's not completely assembled yet. And, the example of an IKEA table came up as well. Some of the argument got into the technicalities of, like, what exactly is included in these parts kits, what's a frame and receiver. More broadly, a lot of the justices were drawing these analogies to other sorts of items that were pretty comfortable to call tables, even though they're unassembled, or omelets, even though they're unassembled.
The ghost gun kits don't come with fully assembled frames or receivers, the core component of a firearm. So a kit might require the purchaser to drill some holes so that pins can be inserted. The challengers, the gun manufacturers, and gun rights supporters argue that's what puts the kits outside the law. But their attorney, Peter Patterson, faced a tough audience, especially from the Chief Justice, who didn't seem to be buying that argument.
What is the purpose of selling a receiver without the holes drilled in it?
Well, some individuals, just like some individuals enjoy working on their car every weekend, some individuals want to construct their own firearms. So the purpose of selling it is to allow
I'm sorry, go ahead.
Is to assist and provide individuals with material with which they can do that.
Well, I mean, drilling a hole or two, I would think doesn't give the same sort of reward that you get from working on your car on the weekends.
Yeah, so I thought that line of questioning from Justice Roberts was really interesting, I think especially if you're trying to read the tea leaves and sort of think about where some of these justices will vote, and I think Roberts is a kind of important one in this case. He asked straight up, like, what's the purpose of selling a receiver without the holes drilled in it? And, one answer from Patterson is, people buy this as a hobbyist, right? In the same way you might buy, like, a collection of unassembled parts to make, like, a little toy ship or model or something, or working on a car and you enjoy it. And Justice Roberts really did not seem to be buying that answer, right? He said, drilling a hole or two doesn't really give you the kind of reward you get from working on your car over the weekend. And I think he's exactly right there, right? So, like, when you look at how these guns are marketed as well, these parts kits are not marketed for hobbyists. Like, they're not described by language like, this is a really leisurely, enjoyable, difficult build, right? They're marketed in terms like, this is extremely fast and easy. This is ridiculously easy. Like, this is dummy-proof. Like, you can do this really fast with no expertise. And so I think that analogy that Patterson was trying to draw between buyers of these kits and hobbyists just really fell apart. And I think there's a great question from Justice Roberts and also gives some insight into where he might stand on this case.
Is anyone arguing that this isn't a kit to assemble a gun? What I'm getting at is, are they just looking for a loophole here?
Yeah, so I think everyone agrees that these are kits to be assembled into a gun. Vanderstock's argument is just because it's a kit that you could assemble into a gun does not, in fact, make it a firearm within the meaning of the statute. And the government sees the statutory meaning of firearm to include these kits. One other interesting thing that came out to your question is there was some discussion, a lot of discussion actually, about kind of where to draw the line. And I think even Patterson conceded that a firearm that's disassembled is a firearm. And so this question about how close does it have to be? And so, the government's argument is, once it's readily convertible, which these kits they think are, that's good enough. And so the term firearm should encompass these kits which could be readily converted to function as firearms very quickly.
Justice Gorsuch asked questions of a textualist nature. Where do you think a textualist analysis gets you here?
So there's two questions in the case, right? So the first one is about whether a parts kit falls under Part A of this statute. So any weapon which will or is designed to or may readily be converted to expel a projectile by the action of explosive. As a matter of textualism, I think that question in this case is extremely straightforward, that these parts kits fall under that language just as part of the ordinary meaning of firearm and then underscored by the statutory language. Like the statute explicitly contemplates things that could be readily converted to expel a projectile, which just seems to be explicitly describing things like these parts kits. And then question B, the second question in the case, is about the meaning of the frame or receiver of any such weapon in the statute. And many of Justice Gorsuch's questions had to do with that second question. So there, the question is, if these companies sell an 80% receiver, which as the government says, you have to drill a few holes in to convert this to a 100% functional receiver, does that count as a frame or receiver within the meaning of the statute? And so, Justice Gorsuch was asking a number of kind of interesting questions about that. And going in, I would not have, kind of as a matter of politics, expected Justice Gorsuch to be favorable to the government in this case, but his questions sort of suggested some openness to following the text, in this case, to a place that might not lead to the sort of conservative politics. So he was asking, when you look at this statute and look at the context, every other part of the statute is contemplating convertible parts in addition to fully functional parts. And so in that context, might we understand frame and receiver, just giving them the ordinary meaning in that context, to also include things that are extremely close to functional and frame and receivers. I thought it was a really interesting kind of exchange between Gorsuch and the Solicitor General on that point.
So the Solicitor General mentioned several times the explosion in crimes committed using ghost guns, and that the new regulations are crucial for solving gun crimes. And also you had a group of 20 major cities filing with the Supreme Court saying that the regulation appears to have been effective, reducing the use of ghost guns. Where does that fit into the Supreme Court's analysis, especially if it's a textualist analysis?
That's interesting. If you think about textualism sort of as stated, right, the idea that the court will resolve this question just by looking at the statutory text and giving that language the meaning it would have in the eyes of an ordinary reader, you might think those considerations about the practical consequences are irrelevant. Like that's exactly the sort of political consequential decisions that they're trying to screen off with textualism. So what's interesting is if that's right, it looks like actually a majority of the justices are inclined to read the text in line with the government. That would be the three Democratic appointees and then potentially Roberts, Kavanaugh, Barrett, Gorsuch. I think Roberts in particular was responsive to some of the government's arguments about the practical consequences kind of over and above the text. So currently, federal law prohibits selling firearms to 21-year-olds. It requires background checks, serialization, all these requirements. And if the court decides that these kits are not firearms, those requirements will not apply at the federal level. And so there's a real concern, right, that again, if people who are buying these kits are not hobbyists, but rather people who just want a firearm, there's a real circumvention concern that basically all of the law that would apply to firearm regulation effectively is meaningless because someone could just get a ghost gun and build their own kit in 20 minutes or however long it takes. And so, some of Robert's questions, I think, were very much kind of responsive to that set of concerns and the principle that if you read the statute in that way, the way Vanderstock wants it to, you'll render a big chunk of federal law meaningless. And so Congress was really underscoring.
Just a few months ago, the Supreme Court, in a 6-3 decision, tossed out a ban on bump stocks. That Cargill case was also a statutory interpretation case. Does that case have implications for this Vanderstock case?
That case It actually concerned a different firearm statute, so it concerned the definition of machine gun. Wherever you come out on Garland versus Cargill, whether it's sort of easy or difficult case textually, the case that they heard to Anderstock as a matter of language is like just much more straightforward. I think it's reassuring actually that the court's oral argument, many of the questions, especially from Barrett and Roberts and Gorsuch and Kavanaugh, really seem to recognize that fact. These gun part kits are firearms in ordinary English. And then the statute explicitly talks about weapons that can be readily converted to expel a projectile, which, also really underscores that these sort of kits are included. And the context indicates the same with the frame of receivers. And so for this oral argument, I think if you think the court is primarily a political actor, you see the bump stock case, you think this is going to come out the same way, 6-3. After the oral argument, I've got a little more hope that the court's going to follow the text, although time will tell.
Thanks, Kevin. That's Georgetown law professor Kevin Tobia. A note, Michael Bloomberg, the founder-majority owner of Bloomberg LP, the parent company of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety. You're listening to a special holiday edition of the Bloomberg Law Show. Up next, a death penalty case that finds the state of Oklahoma siding with a defendant on death row. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is a special holiday edition of the Bloomberg Law Show. I'm June Grasso. We're looking at some important Supreme Court cases this term.
Attorney General Drummond did not confess error here lightly. Indeed, he continues to defend multiple capital convictions and opposed Mr. Glossop's penultimate cert petition. But after commissioning an independent review, he reluctantly reached the conclusion that Brady and NAPU violations by the state's own prosecutors obligated him to confess error and waive procedural obstacles.
It's a very unusual death penalty case where the state of Oklahoma is coming before the Supreme Court on the same side as a defendant on death row, arguing that Richard Glossop's 1997 murder conviction and capital sentence should be undone due to prosecutorial misconduct. Former U.S. Solicitor General Paul Clement argued for the Oklahoma AG, Gentner Drummond, who had made an extraordinary concession known as a confession of error, admitting that the prosecutor in the case withheld evidence from the defense and elicited false testimony from the state's star witness at trial. The prosecutor's handwritten notes, which were unearthed in 2022, reveal that the state's star witness had been diagnosed with bipolar disorder and was being treated by a psychiatrist with lithium. Several of the justices seem to be divided about how important that evidence would have been to the jury. Here are Chief Justice John Roberts and Justices Elena Kagan and Brett Kavanaugh.
Because the jury knew about the lithium. And what they didn't know is that it was prescribed by a psychiatrist. Do you really think it would make that much of a difference to the jury?
That seems pretty material to me. I mean, it's just your one witness has been exposed as a liar.
Would have made the conviction more likely if the jury knows that not only does he have an incentive to lie, that he's lied on the stand and that he's bipolar, therefore creating all sorts of avenues for questioning his credibility.
Glossop has faced 9 execution dates and eaten his last meal 3 times in his more than 25 years on death row. Joining me is Cliff Sloan, a professor at Georgetown Law, who's argued several cases at the Supreme Court, including a victory in a case involving the death penalty. Tell us about the evidence the Oklahoma AG found a few years ago about the state's star witness who testified against Glossop in exchange for not getting the death penalty himself.
So what was discovered was very important prosecutorial notes establishing that the main witness and really the only witness tying Glossop to the murder had a bipolar disorder and had received lithium under a prescription from a psychiatrist. And this was directly contrary to this witness's testimony at the trial, where he said he had received lithium for a cold, and he flatly said he had never seen a psychiatrist. And right there in the notes of the prosecutor are notes establishing that it was from a psychiatrist, and also there was separately a medical record establishing that the psychiatrist had prescribed the lithium for the bipolar disorder. This would have been extremely important to the jury, both in its consideration of guilt or innocence and in its consideration of the death penalty, because the witness was really the entire case against Mr. Glossop. It's undisputed. Mr. Glossop had no role in the actual killing of the victim himself. The theory of the state was that he hired this other man, Sneed, to do the killing. And so Sneed's testimony was the only thing that linked Glossop to the killing.
What's so unusual in this case is that Oklahoma's AG is arguing, along with Glossop, that his murder conviction should be set aside.
The Republican Attorney General of Oklahoma, who generally is very much in favor of the death penalty, has really acted in the finest traditions of justice here, because he commissioned an independent investigation which concluded that Mr. Glossop's conviction and his death penalty cannot stand because of this false testimony and because of the failure to turn over important evidence to the defense, which is a constitutional violation. And so he concluded in good conscience he had to stand up and say that the conviction should be set aside and the death penalty should be set aside. And there also was another independent investigation commissioned by the Republican state legislature, which reached the same conclusion. But what is really striking here is that the Oklahoma court flatly rejected the very considered decision of the Oklahoma Attorney General that there needs to be a new trial and that the death sentence cannot stand.
And at the oral arguments, a lot of time was spent on the procedural question, whether the state court's decision rested on independent state grounds, in which case the Supreme Court couldn't review the case, something Justice Samuel Alito kept pressing.
Well, that's the issue that's presented about whether there's a threshold procedural problem that is based in state law and that would prevent the Supreme Court from reaching the federal constitutional issue. So it's an important threshold issue, but you had other justices very much emphasizing that they don't think that is a serious problem, that they think it's clear that the Oklahoma court rested its decision on an erroneous analysis of the federal constitutional claims, that the state procedural reference was wrapped up in that. And you even had Justice Kagan asking a question where she suggested that the reference to the state procedural issue was simply because the Oklahoma court was throwing in the entire kitchen sink. And so it was just mixed up with a lot of other things. It had no independent basis. And you also had a number of the justices, including Justices Kagan, Sotomayor, and Jackson, emphasizing that this supposed independent rule that the Oklahoma court was enforcing had never been enforced in this kind of context in any case other than one involving Richard Glossop, which added to their view that this is something that was a make-weight, that Oklahoma was just throwing in and is not a bar to Supreme Court review.
So Glossop has a claim of a Brady violation where the prosecutor didn't turn over evidence, and also a NAPU violation where the prosecutor presented false testimony and didn't correct it at trial. Here's Justice Kagan on that.
A NAPU violation is a pretty dramatic thing when a prosecutor says, whoa, stop there. That was a lie.
Under NAPU, a prosecutor, of course, cannot put on perjured testimony, and if the prosecutor learns that the testimony has been perjured, the prosecutor has to, correct it or notify the defense about it. And here, what the independent investigations have found is that the prosecutor put on perjured testimony, never corrected it. To the contrary, took efforts to protect it. That's a very, very serious constitutional violation. It goes to the heart of what the criminal justice system should be about. And, some of the justices were very much bothered by this violation and seem to think that it's open and shut. Other justices seemed more skeptical about whether it was as clear a violation and also how significant it would have been, in terms of materiality, which is important for NAPU, and whether it would have made a difference or not. So I think there's clearly a split among the justices, both about the procedure and the substance in terms of how they're viewing it.
It's always hard to read through oral arguments what's going to happen, and particularly in this case where a lot of the justices said very little. Do you have any idea of what the lineup might be from these arguments?
Well, with the usual important caveat that it's always very difficult to predict, here's what I took away from the argument. And by the way, Justice Gorsuch was not participating. But it seems from the argument that Justice Alito and Justice Thomas were very hostile to Glossop's claims and to the position of the Oklahoma Attorney General, and very skeptical of it. It seemed that Justices Sotomayor, Kagan, and Jackson were very sympathetic to the positions of Glossop and the Oklahoma Attorney General. And so that leaves Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett. And I think it was difficult to tell from the questions exactly where those three are. And I think that, that's going to be the ballgame, where those three justices are.
There did seem to be some support for a sort of middle position, remanding the case back to the state court for an evidentiary hearing.
A couple of the justices were suggesting that perhaps what should happen is that it should be sent back for additional fact-finding about exactly what happened and how important it was. Some of the justices were very explicitly saying that they didn't think that was necessary in light of the record and how clear the violations were.
The Supreme Court rarely grants relief in death penalty cases. Tell us about the Roberts Court's history in this area.
Well, I think that the way in general that the current Supreme Court is approaching death penalty cases is very, very troubling. It's very, very difficult for capital defendants. The court is creating all sorts of new procedural obstacles, and it's also, as a general matter, being very unsympathetic to claims of capital defendants. Now, that's not, 100% of the time. There have been, a few cases in recent years where the court has ruled for capital defendants, but overwhelmingly, the court is dramatically tilting the playing field in favor of the death penalty. And, the Glossop case really illustrates three of the most troubling characteristics of the death penalty in the United States today. One of them is the prevalence of cases of innocence and exoneration of people on death row. There have been 200 people on death row who have been found to be innocent and who have been exonerated, a truly shocking and alarming fact. The second problem that it highlights is misconduct by prosecutors. In 70% of the cases where there has been found to be innocence of people on death row, there has been misconduct by prosecutors. Exactly this kind of thing, putting on false testimony, not correcting it, not turning over very important evidence. And the third very disturbing problem is when courts don't accept prosecutors' conclusions that a conviction and a death penalty cannot stand. That happened recently in the execution of Marcellus Williams, and we're seeing it in the Glossop case.
And in Glossop's case, he can only afford to lose 3 votes because with 8 justices hearing the case, a 4-4 vote would affirm the Oklahoma court's ruling against him. Thanks so much for being on the show. That's Professor Cliff Sloan of Georgetown Law. And that does it for this special holiday edition of the Bloomberg Law Show. I'm June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.